But let's bring in our guest for this hour. Joining us now, National Trial Attorney Michael Jaafar. Michael, that was the family court judge there at the end, of course, before Doug Benefeld was killed. But the judge that we have actually over the case we're in now, the murder trial, this morning the defense tried to get him to recuse himself because of how he characterized the denial of the stand your ground immunity case. I mean, this seems like a Hail Mary that the defense was trying to throw up on the eve of trial. But your thoughts on where a defense finds this idea of deciding, let's try and go after the judge just because they made a ruling previously against us?
That move by the defense attorney confused me. I've got to imagine it has something to do with that bizarre colloquy that same judge had with Benenfield, where he just went on and on and on, I think, for 30 minutes, preparing for a 3850 motion, which is a post-conviction motion. I have to assume it has something to do with that, because not out of vindictiveness, but because I think they think that they're going to have to, they have grounds, they have an opening to, file for a new trial if this goes against them by basically combining the two, his denial of the stand your ground motion along with, his bizarre colloquy. I don't think it's smart. It kind of confused me a little bit, but I have to imagine that has something to do with it. To be quite frank with you, if you ask me in 1,000 trials, how many times do I see an attorney file a motion for the judge to recuse himself the week before the trial? I would probably say 0. Now I have to say 1 out of 1,000 because of this case, but it kind of confused me. But that's the only thing I can imagine as being the impetus behind it.
Yeah, that was a weird colloquy. Last week.
Let's talk Marsha Thompson a bit. The jury out now just over an hour. What's your take on this one now that we've seen the evidence in this case? What do you think is going to take place in terms of, do you think the state was able to prove their case beyond a reasonable doubt?
Here's what I think. I think law school professors from around the country are rubbing their hands and saying we have a perfect case to use in teaching new law students about the battered abuse wife syndrome defense, because this case has everything. In law school, they don't test you on things that are slam dunks. You're expected to know the elements before the first day of class. They test you on cases that could go either way. So to answer your question, Ted, I think the murder one charge was appropriate at the time it was given. If you're an investigative agency, you're not there to try exotic defenses such as battered spouse syndrome. If you take that out of the equation, what do you have? You have a trained law enforcement officer wearing a vest, shooting another person 9 times while they lay on the couch, because that's what the state knew before, when they made these charges, because they had the examiner, they looked at the forensic evidence, they looked at the pillow, and that is what they had, right? When you inject that in, by the way, she had some zealous advocacy by her defense attorneys. I mean, her defense attorneys really want to acquit their client. When you add that in there, it makes it very difficult, right? I think in their closing arguments, the prosecution missed the lead, which is, hey, a lot of us know somebody who's kind of a bad person, but if you woke up one day and you found out that they were shot 9 times while they were laying on the couch, you would assume someone's going to go to jail for that, right? They kind of missed that, and it was a very disrupted type of closing statement. But other than that, I think this is a tough one, Ted. It could go either way because the facts go against her, but she goes in her favor. She was an amazing witness in her own defense.
A tough one for this jury. They've been out for an hour and 10 minutes now. We'll get you back into that courtroom if we see any movement, if they have a question or a verdict. But for now, still ahead, we're going to check in. Well, let's bring in National Trial Attorney Michael Jaafar standing by. Michael, your reaction to the flyer. Who did it?
Oh, yeah, the flyer. People like Sarah Boone are not unfamiliar to any public defender in the world, right? There are people just like that all around in our system who really want to micromanage everything they do, and they have severe mental health issues. And this is on display. I'm not going to say there's any strategy behind what she's doing. She's obviously having a breakdown, a mental collapse. This is a person who, in my opinion, is not fit to stand trial. I'm not a doctor, but I mean, she fired 8 lawyers. She put up this really well-written, drafted, well-designed, choreographed flyer. This is a person who, what do we do in our system? I remember when I was a young attorney being trained by older lawyers, and they take me to the jailhouse, and they'll say, hey, we're going to interview a witness. And I noticed, hey, a lot of the people here, you know, have a couple of screws loose. What's going on? And the senior attorney looked at me and said, pretty much 95% of the people who are in jail are the same. They have mental health issues. They're here. This is our society's way of treating mental health issues. Sarah Boone she's no different. So it's a pretty sad exhibition of, you know, a mental health collapse, and that's what we're looking at.
Yeah, it's something else. This case has been going on for years, and we'll see what happens next with